5 seconds to go. Start. India has ratified the Convention on the Elimination of All Forms of Discrimination against Women. Article 12 of CEDAW requires the state parties to take appropriate measures to eliminate discrimination against women in the field health care services in connection with family planning, pregnancy, confinement, and postnatal period. Similarly, Article 16 urges state parties to eliminate all forms of discrimination against women and to ensure that they have the same right to decide freely and responsibly on the number and spacing of children and access the relevant information to effectively exercise these rights. The UN Committee on the Elimination of Discrimination Against Women emphasized that state parties should undertake appropriate measures to eliminate discrimination against women in their access to health care services, particularly in areas of family planning, pregnancy, and confinement and postnatal period. It is also urged that state parties should refrain from imposing barriers on women who seek to pursue their right to access health care, including reproductive health care. India's obligations under international law require the state to bring the MTP Act in conformity with said obligations. The reproductive rights of women must be harmonized in light of the principles laid down under the Constitution as well as the principles of international law codified in the various international conventions ratified by India. Our interpretation of the MTP Act and the MTP rules furthers India's obligations under international law. However, the state must act proactively in order to ensure that women in India are able to actualize their right to reproductive health and health care in line with the obligations assumed by the country under international law. The realization of reproductive autonomy is possible only by addressing problems in the societal context within which individuals, particularly women, are situated. It is not only social stigma which prevents women from realizing the right to health, but also caste and economic location. The cost of an abortion at a private hospital may be prohibitive for those whose monthly salaries are a fraction of that cost. Public hospitals in rural areas are often not equipped with the resources to provide the kind and quality of health care that ought to be provided free of cost or at highly subsidized rates. A lack of awareness about the resources that public hospitals offer, coupled with the discriminatory attitudes of many health providers, only serve to exacerbate this problem. The MTP Act recognizes the reproductive autonomy of every pregnant woman to choose medical intervention to terminate her pregnancy. Implicitly, this right also extends to a right of the pregnant women to access healthcare facilities to attain the highest standard of sexual and reproductive health. It is meaningless to speak of the latter in the absence of the former. Reproductive health implies that women should have access to safe, effective, and affordable methods of family planning and enabling them to undergo safe pregnancy if they so choose. The directive principles of state policy in Part 4 of the Constitution lay down the fundamental principles in the governance of the country and press upon the state to apply them while making laws. Article 38(2) of the Constitution requires the state to promote the welfare of people and eliminate inequalities in opportunities. Stop.